What's up, everybody? Welcome back into the episode of the Lawyer You Know podcast. And we are recapping week one plus a day of Donna Adelson's trial. The state thinks they're going to finish. It's not quite the end of the day Friday, so I don't know if they've actually closed their case in chief yet, but we've heard the vast majority of the state's evidence. Have they proved this case beyond a reasonable doubt? They have charged Donna Adelson with three different things. Kind of weird. Why was it done that way? Some things have happened in this trial that people say, is that just how it's done in Florida? Well, I've brought on the perfect guest to dig into all things Florida specific, especially when it comes to criminal defense, especially when it comes to being in the courtroom. So let's get to it. Welcome into my dad, George Tragos. For anybody new to the channel or new to this case that hasn't met him yet, he is a Florida criminal defense attorney. He's been an attorney for what, 50 years? Is that the button you got? 50 years. Yeah. As an attorney.
Give me a plate.
Crazy. He went to Florida State University College of Law, which has a major connection to this case. We'll talk a little bit about that, I'm sure. Was a former prosecutor at the state level, chief assistant U.S. attorney at the federal level, so prosecuted cases state and federal, and has been doing state and federal around the country, criminal defense throughout the rest of his career. And taught me everything I know about criminal defense. So perfect guest for this situation. We have a Florida case. It's a criminal defense case. It is a conspiracy case dealing with a wealthy South Florida family and two law professors over at Florida State University College of Law, at least back in the day in my time at FSU College of Law, and an incredibly sad story. And we have had so many twists and turns to get us to this moment. But the big question everybody has had from the jump of this case, and as we're kind of going through the evidence, is why did they charge Donna with three different counts? One is first degree M, one is conspiracy to commit M, and one is solicitation. So why did they pick those three charges? What are the differences, and what does the state really need to prove to get the convictions across the board?
In those two, you can be convicted for hiring somebody to do M, or just getting with a group of friends, talking about it, and then buying a gun or something. And so you can be convicted of those cases without actually having someone die.
So the interesting part about this case is, though, nobody's really questioning the death. So why would they pick all three charges in a case where the death is not something that's, maybe the jury's going to split the baby and say, well, we're not sure if the person died, so we're just going to go with solicitation or conspiracy. Why did they choose to prove all three? And again, still talk about what the difference is to actually get her on the first degree.
Well, I've got to be honest with you. It is really redundant in this case to charge solicitation and the first degree. It really is, because all of the elements are pretty much the same, because they're going in the principal theory. And they said that in the opening, aider, abettor, she didn't actually do the act, but the fact that she aided, abetted, procured, hired, all of those things make her a principal. Those are also all the things that make her in solicitation, the same thing. So it is redundant. They may be thinking they're worried about a compromise. They may be thinking that the jury will say, well, if she didn't actually participate in the act, then maybe we shouldn't convict her of the act, but we can sure convict her of the conspiracy and the solicitation. So they may just be hedging their bets for the jury.
And it's really a jury's understanding of the law, not what the law actually is. Yeah, and that's what it comes down to with the evidence and how they present it. Is it really seems more like a hedge on what the jury's understanding of the law is. They don't want a juror, one or all of them, to get confused and think, oh, it's definitely not first degree because, and we heard it in the recordings, right? Charlie's like, they can't connect us to Garcia, the shooter. There's no DNA. There's no fingerprints on the firearm. So that's what the Adelsons were thinking, is they're never going to get us for this because we don't have that direct connection. We have an alibi. We weren't there. It wasn't us. They'll never be able to connect it back. So we're not going to get first degree. That's not how the law works. When it comes down to what evidence has actually been presented, what do you think has been some of the key testimony and evidence in this case that we want to walk through here in our week recap?
Well, one of the things everybody should keep in mind is, this is kind of funny, but this is a kind of a microcosm of an organized crime family. That really is what it is. It's much smaller. It's only a couple people. But you think about the racketeering cases in New York where you had Joe Bonanno. The reason they had to have those kind of cases is because they had to get the guy at the top. He may not have actually committed the act, but you've got to convict that guy. And so that's why you had those prosecutions, and that's why they went all the way up to the top. And that's what they're doing here. I mean, this is basically a crime family. I mean, you take a look at how many of these people are in prison, could be in prison. We don't know what they're going to do with Wendy or the dad. But, you've got a situation here where you've got a crime family, and who's the boss of the crime family? That's what this case is trying to establish. Is Donna the boss of the crime family? And so so that's where they're going. So if you want to, start, well, I guess we should start with day one. Well, I skip over
Sure.
the openings probably, but
Yeah. I mean, the openings laid out the case. I think they did a good job, especially because they know what the defense is going to be. Do you have any comments just generally about how you thought they did on opening, prosecutor versus defense, grade them, who you think connected more with the jury?
well, the prosecutor did an excellent job. If the prosecutor, and from what we've seen, the prosecutor can prove all the things that the prosecutor says they can prove in order to prove the case. They did an excellent job. The defense really is relying on the fact that she's just your average mom. That sounded like their pitch. She's just a regular, everyday, normal mom, and that was their pitch. And normal moms get upset when their daughters don't get to move back home, and normal moms may say things, but she's just a normal mom with no intent to hurt anybody or kill anybody. So
Yeah.
that was their pitch.
Yeah. I mean, that was their pitch. And their pitch was also that other people did this without her knowledge. And they left the door open for conspiracy or for extortion, like Charlie's defense. But also, in their opening and throughout their cross, they've really done a lot of finger pointing at potentially it's Charlie, potentially it's Wendy. Everybody else knew more and was more involved than Grandma Adelson over there, who's just a nice old lady sitting at that chair. Does that really look like a killer to you? Yeah.
And another key area is motive. They've all really honed in on motive and how important motive is to getting a conviction.
Yeah. And that's, I mean, in cases where they have to argue, the state says we don't have to prove motive. Those are difficult cases. The jury usually wants to know why somebody committed a crime. And sometimes motive can be the most important factor. And in this case, because they have that family law file that they've been able to read the vile things Donna Adelson said and was willing to do to Dan Markel, that's some of the most important motive evidence, which they laid out from the opening, and it's been consistent throughout the case. But we can get to day one. Okay, who do you want to focus on day one witness-wise?
Well, I got to tell you, I would the whole day I would just jump all the way to Rivera.
Okay.
I've got to be honest with you. I mean, the other people were necessary. You got to show the guy got shot. You got to show the guy died. You got to show how he died, bullet wound.
And you mentioned that before. You have to show that because the first degree, you have to prove that somebody died.
Right.
You can still get solicitation, you can still get conspiracy. The defense did not fight that. What did you think of the defense really going in thick in opening and throughout the case about, Danny was a great guy. It's the last time Danny saw his kids. It's so sad. Danny was brilliant. Danny was the best. Like, what did you think about that strategy from the defense?
I guess that's just a strategy. You've got to pick a strategy. I hope that the problem with this that I have is I don't know what strategies. Well, I can guess on the other three, or actually four trials, or three trials, right? Three trials. Other three trials, they didn't work. And so maybe they're trying something different here in trying to show that he's a great guy, and we really loved him till he wouldn't let the daughter move back here. We thought he was a great guy. That's not a strategy I would use. But they can try something new. Maybe that's what they're doing.
But that doesn't help. Number one, if you admit that you stopped liking him when he wouldn't let your daughter move home, because that's when the motive starts. Number one. Number two, I think that's a fine strategy, unless you have emails calling him horrible names, saying you want to do horrible things to him, saying you want to do things to his kids that he would find to be deplorable and soul crushing. And when you have those emails in your own words, signed mom, Donna Adelson, like that strategy goes out the window to me. I like the strategy of she didn't know whatever she was doing with Charlie and Wendy. It was at arm's length, and they knew so much more than she did. She just loved her family and trusted her family to do. I think that's a better strategy. Again, one that eventually probably falls apart, but All right. Sorry, I interrupted you because
No.
there's so much theory throughout that did start in opening. I think both sides have weaved that theory throughout the case, exactly what they said and what they were going for in opening. So,
Yeah.
all right, Luis Rivera, did you find him to be credible?
All right. I found him to be credible only because of what happened later in the other testimony. I don't find guys who are facing life sentences or the death penalty to be a very credible witness, because what do they have to lose in coming through and saying anything that they brought him in jailhouse garb, they brought him in chains, and he sat there with that stuff. He got one heck. I mean, I know a lot of people may not think 19 years is a heck of a deal, but 19 years is a heck of a deal when you're looking at life or the death penalty. He got 19 years. So what wouldn't a guy like that do? I mean, do you really think he wouldn't lie? I mean, you really think that Rivera is the kind of guy that would never lie to get himself out of a life sentence? Of course not. So, and I tell you, prosecutors lose cases all the time with these guys that come in that have life sentences and turn around and testify, and that's all they got. They lose those cases all the time because juries look at the guy just like we would and say, "Oh, come on, who wouldn't lie? This guy is a liar. He's a criminal. He killed somebody." So on his own, I didn't buy him. Later on, with all the stuff, which is the way the world goes, I did. But on the first day, I really didn't buy him. He pled to second-degree murder, and he's got a concurrent federal sentence, which, by the way, I'm not sure. They didn't get into this, I don't think. But if he serves those 19 years in a federal facility rather than a state facility, it's going to be a much nicer 19 years. And that may be part of the deal, but no one got into that. No one asked it, so I don't know. That would be my deal. If I was a lawyer, that would be the deal I make.
Thanks to Green Chef for sponsoring this episode. Summer's coming to an end. School is starting. This is the busiest time of year for us. So that's where Green Chef can come in to help make healthy meals faster and easier. You don't have to think nearly as much. You pick what you like. They send you boxes that fit within the parameters that you want. We picked fit and healthy and quick and easy to make. And they sent us 4 meals that my entire family absolutely loved. And they were different. There was some ground turkey and pasta that we really liked. There was a salmon meal that we absolutely loved eating together. My kids love salmon. So it's been really fun trying different things with my kids, but it's still being easy and healthy as the school year has started for us. Make this summer your healthiest yet with Green Chef. Head to greenchef.com/50LYK and use code 50LYK to get 50% off your first month, then 20% off for 2 months with free shipping. That's code 50LYK at greenchef.com/50LYK. Yeah, to me, I did find him credible, and it's hard for me to separate because I know you haven't watched all the other cases, but I've watched all the other trials, so I knew how they were going to corroborate a lot of what he said. And later on, when they talk about he told them about the bullet in the floorboard of the car, and they were able to go back and match that up, and the text messages, and a lot of things corroborate exactly what he said. But some of the things that are good when you have somebody in the orange jumpsuit there testifying is when they're making statements that make themselves look bad. Usually jurors can't comprehend that. They're like, he was not going to lie and say he did something like that. And he's kind of like a stone cold type of guy is what he felt like. He didn't have any problem saying exactly what he said he did. But you're right. The fact that the state had so much corroborating evidence is what gave him the credibility that I think they've been building off the entire case, and more about that when we get to Katie Magbanua later. But I do think he was probably the highlight of day one for most people.
Yes. If we look at this like a movie, this is going to be a great movie someday. This is, he's going to be one of the, key parts of the movie.
Yeah. People are going to think it's too unbelievable to be a movie. Okay. Day 2, we had Investigator Newland. We had Wendy Adelson. I assume you want to talk about her.
Yes.
Okay.
Yeah. She's the next big one.
Before we get to that, because I think you're going to probably want to do the sexier witnesses that, the ex-boyfriend, the ex-girlfriend, Wendy, all these witnesses that have a lot to say and are kind of like the highlights. But I do think one of the biggest pieces of evidence in this entire case and what Investigator Newland focused on is that family law file. First question is, do you think it was appropriate that it came into evidence in this case?
Yes, I did.
Why?
Well, first off, you can take judicial notice, evidentiary judicial notice of a court file. So the authenticity of the file is not in question. That's number one. Number two, it's the motive that the state was trying to put forward. So, the motive was in that court file. That was part of that file. So I don't see it had relevance and it was authentic. So I don't see any reason why it should not come in.
Yeah, I think that it was relevant. It was authentic. It was a million statements that were bad for statement against interest. It was Donna Adelson's own statements, which they can use against her. It definitely proved motive, and a lot of what they were saying didn't even have to be used for the truth of the matter asserted. So hearsay, they were going to be getting around a lot of those objections. So I think it's an interesting legal discussion, and the argument of whether or not would come in was kind of fun. But I think ultimately the judge made the right decision because it does give a lot of context, especially to motive, which is very important in a case like this. And I thought the state used it really, really well, picking and choosing what emails to read. The relocation motion getting denied with prejudice. The defense did a good job of talking about how that was stipulated to by Wendy, which we'll get to when we get to Wendy. But ultimately, the grandma motion to try and restrict Donna Adelson's connection with the grandkids, I think, was huge. And the fact that that was never heard. And right after Dan Markel dies, Wendy moves back down to South Florida, changes the boys' names to Adelson, and everything they always wanted happened right after he died. So not only was there motive, but there was specific motive for Donna, and she got what she wanted after the death. So she benefited from this crime. I think that was all really important kind of from the jump.
I think, and again, I could be wrong, but I think she did that name change on an invite before he was dead. I think
Maybe.
that's one. I think that's one of the things they focused on was
Yeah, maybe
in that invite, she changed the name to Adelson of the children before the death.
Oh, interesting. I may have completely missed that. There's a
Yeah,
lot of details in this case. All
oh
right,
yeah, tons. Oh yeah.
let's get to Wendy. So what did you think of
Okay.
Wendy's testimony? Because it's the first time you've heard her testify, I assume, right?
Yes. Yes.
Okay. What did you think?
Uh, Wendy obviously was dancing on the head of a pin during her testimony. She was trying to make sure she didn't get charged with a crime by, testifying, but she also was very hesitant about giving them real bad stuff about her family. So it went back and forth, stuff she couldn't deny. She had to admit. I tell you what, I don't understand. Again, she's a lawyer. How did she not know about her previous testimony or her previous emails or text messages? They constantly brought up inconsistent statements during her testimony where she would say, "Oh, I was happy to live in Tallahassee." And then they say, "Well, didn't you say here that you hated Tallahassee like the plague?" I mean, so how did you? "Oh, yes, I did say that." And that came up not just once, but repeatedly. The state brought up inconsistent statements. So I thought that was a really bad look for her. And I don't know why she did that. There was no reason for it. If she's trying to keep herself out of trouble, that was a mistake. She, let's see, she was good about the dominant mom. She was the dating profile, I think, is again what the state's trying to create, the dominance of the boss, the dominance of Donna. So the dating profile, the dominant mom, the religion aspect, the wanting her to move back to Miami. She established all of that, which I thought they needed. Oh, the other thing they needed, and people might not have, I think the average person probably wouldn't have recognized this, but they needed her to authenticate the voices. She was able to authenticate all the voices on the wiretaps and on the telephone call, all that stuff, because somebody has to say who it is that's speaking. And she authenticated the voices. And although to guilt or innocence, you may not think that goes a long way, but it sure goes a long way to the evidentiary issues that a prosecutor has to overcome in order to introduce that material. So she did that. On cross, they talked about the $1 million to relocate that the mom wanted to pay, but she never paid it, and I think she never even offered it, that $1 million. Let's see.
Well, let me ask you this.
Go ahead.
One of the big things about Wendy in the question everybody has, and let's get your answer on it. I've already kind of given mine, but what is derivative use immunity? What is the type of immunity she's gotten? Can she still be prosecuted? What can be used against her? What can't be used against her? Let's talk about her specifically. And then I also want to kind of get your thoughts on what you think about that. Do you think it's fair that the state can do that, that the defense can't? Because that was a big motion before the court, that was something Catherine Magbanua appealed and ended up losing, saying it was not fair that they weren't allowed to do things like that the state can call her, can pick what they're going to ask her about, can limit what cross is about, and the defense doesn't get to get the information they want from her.
Well, there's multiple appeals on the fairness of this, and the defense always loses. But there's multiple appeals on the fact that the state has the power to subpoena a witness for trial. And by statute, whatever the witness says on the stand, because it is compelled and involuntary, and it cannot be used against the witness. Just what the witness says. All the other evidence they may have against Wendy, they can use, but they can't use what she said from the stand. Again, that's a statute, and it's only the state's power. It's been upheld over and over again.
Yeah, and to me, that's fair. I get it. It's appropriate. You can force somebody to testify basically as the state. What do you think about the fairness as far as that the defense can't do that, or they can't cross or ask her about other things that they think are important to their defense?
Even though I'm going against all of the judges that have written opinions on this, I think it's unfair. I really do. I think that if the state can compel a witness to testify who may have some incriminating evidence, I think the defense, as part of their defense, should be able to call a witness and compel them. Otherwise, they have a witness that has relevant testimony, and the defense can't call that witness, and the witness will never be heard by the jury because they don't have the same power as the state. I do view it as an unfair advantage by the state.
I agree, but let me ask you this, because we agree on all that, but we may disagree on this, just the way that we kind of try cases a little bit differently. There's some nuanced differences. Would you be okay with, because this was something that was proposed in this case by the prosecutor, and I want to get to what you think about the prosecutors and the defense attorneys eventually, but the prosecutor proposed, why don't you, defense, submit a list of questions or topic areas that you want to get into, and either the judge can look at it or we can look at it. Maybe we can grant immunity for those topic areas or questions as well. What would you say to that if you were the defense to turn over something like that to try and be able to ask her more?
I would do it. And the only
So would
reason
I thought you would not. I thought you'd say, I shouldn't have to ask you what questions I have, because that's usually, I feel like, your vibe. Like, I shouldn't have to ask I don't want to tell him my strategy. So what you would do that. I would 100% do that because I want to try to get the testimony out.
I would do it because there's no appellate issue to preserve. And, if it was, that's what I would think about. If I was waiving an appellate issue by giving him those questions, then I wouldn't give it to him because I want to preserve my appeal. But I know it's a loser appeal.
I was going to say,
I have nothing to lose by giving him the questions. So I would give him the questions.
You are waiving an appellate issue, but it's a loser.
It's a loser.
Right. That's the analysis that lawyers have to do, because there are some things that are not appealable, right? It's in judicial discretion, whatever. You're not going to ever do, but there are certain things that are appealable, but that are going to be losers. And in this scenario, it's going to be a loser. Literally, it's not even like another case that's kind of like your case. It's like almost the exact same scenario. The appellate court has already come down and denied Katie Magbanua's claim to do this, and the defense did not want to do it in this case, which leads me to, we've talked about the direct of Wendy Adelson. What did you think about the defense's cross?
Well, I kind of, it was light. It was, they could have gotten into a lot more because she's up there. They can ask her anything. And
they can't ask her anything. It has to be
anything within the scope of the direct.
Correct.
And they could have gotten, and frankly, I could have fashioned some questions that would be within the scope of direct that would go.
How's everything not in the scope of direct when you went through the whole day and what you knew and who you talked to and what happened and why you did it?
But the one thing they left, and again, memory-wise, maybe you remember, maybe I'm not remembering this. They never asked her about driving the van to the house and turning around. I don't think they ever did. They ask her that on direct?
Yes.
Okay, I just didn't remember that.
Wait, I'm sorry, on direct or on cross?
Either way.
She was asked about it for sure. I assume she was asked about it both, but I'm positive she was asked about it on cross.
Okay. I just didn't remember that because you know why? I didn't really think it was that important until later on when I heard the other testimony and I realized exactly because sometimes things happen early in a trial and you don't realize how important they are until later in the trial, the other testimony comes out. And that's one that the van didn't strike me as, that important till later.
Yeah. And that's, again, think about how a jury feels, right? For everybody listening, like a jury sometimes is really trying to catch up, figure out what's important. And we've had cases where we thought these really important facts, they didn't even realize the fact was there because of the way that it came out. But yeah, it was important because why would she drive by the house? If she saw all the tape there, why wouldn't she? It wasn't like she was looking at the house knowing that it was the house necessarily, but there was testimony that she should have been able to see that it was their house. She wasn't concerned about her kids, wasn't concerned about Dan, just turned around and went, and that was out of the way. Why would she ever take that way? She explains it that that's where she lived. That's how she knew how to get there. So she was driving by her old house because it was familiar. So, she had some explanation, but that's definitely a big one with Wendy as people have gone with how they think she did.
Oh, I
I
definitely
actually think
she passed 3 liquor stores. She was going to a liquor store and she passed 3 liquor stores, I think, on the way there.
they did get some points across on Wendy's cross. And now that I've had the benefit of watching 6 days of this trial, I think it was one of their better crosses, actually. So you didn't think it was good. I can't wait to hear if you think any of their crosses were good, because this one, at least, I do think that they got her to say, like, Donna never said she wanted to end Dan's life or anything like that. Donna babysitted for Dan. She babysat for Dan. She did the Zoom call. She made him banana bread with the way that he likes it or whatever. She was okay with you staying in Tallahassee and keeping the job. And then they pointed the finger at Wendy like, this was all a facade. You didn't even want to go to South Florida. You wanted to stay in Tallahassee. Isn't that true? You stipulated to the order denying relocation. What did you think about that exchange between the defense attorney and Wendy Adelson?
Well, I thought it was good, and I thought they had to bring it up, and it was good that they brought it up. It's going to be a point for them to argue. They also talked about what they got out of her. You talk about staying within the direct. It really didn't go, but the mother was shocked when she heard about it. The mother is a loving, selfless kind, da-da-da-da-da-da-da. She described her mother, in glowing terms. And she had to leave, or she didn't like the job because it was a grant job, and she might lose the grant for the job, and that's the only reason why she was looking for another job. And so if she knew, I guess the inference was, if she knew the grant money was there, she would have been happy to stay.
I don't know. I mean, that to me was not that big of a deal. I think it was all just kind of like she wanted to go to South Florida because after Dan died, what did she do? She went to South Florida. That's pretty clear to me.
All right. Again, for movies, how great is that? Your daughter up there testifying against you. That's going to be another movie moment.
And not just her daughter testifying against her, but also
her daughter,
her son, Rob Adelson, who is the estranged son, basically the one that has no connection to anything going on in this case. He's an ENT in New York, and he had a lot to say about his mom. What did you think about his testimony?
I thought well, obviously the jury's going to know that he and his mother are estranged. So they're estranged for a reason, because they don't get along and they don't like each other. So there was no surprise that he found his mom assertive and controlling, and that his mom's, I guess, closest to or greatest love, however you want to describe it, is Charlie. And so, he described the relationship between the mom and Charlie. So again, they get out their point. She's the boss. And if you don't like the way the boss orders things around, then you leave town. And who does the boss control more than anybody? Charlie. And so they were able to get all that out of Robert.
I think that he was, looking back now again, as we've seen most of the state's case, he was one of the most important witnesses, because I think the defense has done a good job, actually, of downplaying Donna as matriarch. A lot of these people didn't know who Donna was. A lot of these people can't say whether she was controlling. Charlie's not going to say she was controlling. So the family law file and Rob saying that mom, he kind of said she was a little controlling. He didn't necessarily go all the way through, but then you connect that with some of the phone calls about Charlie and Donna talking about Wendy's dating life and where she's going to live and what job she's going to have. So Rob was really important to build all that. But it was also so telling that anytime he would bring it up or want to talk about this, nobody in his family seemed to want to talk about how their brother-in-law was shot in his suburban driveway in broad daylight in Tallahassee. Like, imagine that with our family. If something, God forbid, happened like that, and one of us just never want to talk about it and refuse to talk about it, or if you're the only one in the family that nobody would talk to about it, you'd probably be pretty suspicious as well.
There is one thing that I wrote down that he did say too at the end. Mom said, "Don't talk to the police." I thought that was pretty telling too. That was I think that was redirect. I think that might have come out. So,
I don't remember when it came out, but I'm positive it came out. Not
yeah.
only did she don't talk to the police, she also said like, oh, he doesn't know anything anyways, things like that. When they made an arrest, she called him for his anniversary the next day, didn't even mention it. Like, I mean, I know we have clients, right? On both sides of this, right? Accused of crimes and then victims of these kinds of things and these kinds of crimes. It's all they want to talk about. It's all they want to talk about. Did you hear what happened? They finally got the person, or they're investigating, or we're going to get them, or we're going to get full. It's all they talk about. That is so telling to me right from the jump early on in the case.
Right.
Anything else on Rob?
No.
All right. Next, let's jump to day 3, Jeff Lacasse.
Okay.
Wendy
I was just going to mention Officer Brandon. He was the guy that saw the van come up, turn around, and pull away, and he thought it was very suspicious.
Yeah. I mean, that was kind of BS to me, but that's just a cop. Like, give me a break. You remember that one van that day, and that was suspicious to you? Like, that's the type of evidence. This is a strong case for the state, okay? And I think they're doing a really great job. But, like, that's the type of crap where I'm like, come on, dude. Like, you can't – I don't think you should be able to let a cop say stuff like that personally. I think that's just making somebody look guilty. But from the defense's point of view, it's like, sure, Wendy is guilty. So I guess the defense wasn't going to object to it because they want to point the finger at Wendy. But that's the type of stuff where I do think – they pushed a bridge too far a couple times. And I do want to get to that, like just the lawyering. I don't know if now is a good time. We're about halfway. And let's talk a little bit about.
I was going to say on Wendy, I think you got to realize, I don't know if the state's made a decision on her yet.
Hold on. I don't want to do that topic yet.
Okay.
That's
all right.
what everybody wants to hear. We're going to hold that till the end on who's next. Wendy or Harvey, because they've been going one after the other. So we will talk about that at the end. Don't let me forget. But I want to talk about the lawyering real quick.
All right.
So give me kind of your grade or however you want to do, breaking down how the prosecution team has done and how the defense team has done. And I want to point out a few things. Prosecution's got a really good case. They've tried this case 4 times. Defense is kind of new to the case. It's a difficult case. There's a lot of evidence against them that they're dealing with. The prosecutors already had 2 admitted discovery violations. Although neither were one was immaterial completely, just an enhanced version of a video versus an old version. The one we're about to get to on Jeff Lacasse, maybe I'll just mention it since we're talking about him now. Let me just tell you what it was, because you may have missed this in watching it. So they had him testify that Wendy asked him, when do children actually start getting their memories that stick with them forever? Because he's got some background, and he's like, when they're 4 or 6 years old or whatever, to obviously say Wendy and her family were doing this crime and they were trying to do it hopefully the boys wouldn't remember, to make them look guilty. Objection, undisclosed opinion. And the prosecutor argued they disclose it. They didn't. The defense didn't even ask for a curative instruction. The judge was like, I'm going to give a curative instruction. Defense didn't ask for a mistrial. I know you would have asked for a mistrial. I know we would have fought for an instruction that lambasted the prosecutor. How could you do this in front of the jury? Make sure the jury knows that's total hogwash and you can't consider it. So what did you think about how that all transpired, and weave that into talking about the lawyering on the case?
Well, that's an obvious example of the lawyering on the case. If you don't ask for a mistrial in a lot of appellate courts, you're not going to be able to really appeal that because you didn't ask the court to correct the problem or to start the trial over. You don't ask for a curative instruction. This judge actually has done a pretty good job. I've got to give him credit. He is even-keeled. He does not lose it. He is going through and just calling balls and strikes and trying to make it a error-free trial. He's doing his best to do that. For instance, the prosecutor, again, I think they're doing a great job. But on the other hand, I think it's pretty easy to do a great job when you try the same case 4 times. I just got to tell you that how can you not get better and better each time? So by the 4th time, you ought to be able to do a really good job. And it's the kind of case where there's a lot of technical testimony, and knowing all the technical testimony and how it all fits in to the puzzle. By the 4th time, you know it. So they have a real advantage. However, they are. This may be extreme, but they are abusing their advantage in some way. I think that they are really getting away with a lot in the case. I think that they are not getting things that should be objected to or not being objected to. They are asking leading questions or asking questions where you have these conclusions. They're drawing conclusions from the evidence that really are part of closing argument. But they're able to get him in and say, well, then I guess we can assume that she was right outside his house, because you have later on we'll talk about it, but you had data saying he's right outside the house. So I guess you can assume that this happened. I guess you can. So they're able to draw conclusions and state their conclusions in the questions without objection. I don't know if that's a strategy, but it's a poor strategy, in my opinion, for the defense not to object, because there's a good chance your client's going to get convicted. And if your client gets convicted, then it's going to get appealed. And if it's going to get appealed, you've got to preserve those errors for appeal, because if you don't object, you're not going to preserve those errors. The other thing is, at some point, if she gets convicted, especially if she gets convicted of M, she gets convicted of that, there is an expedited appeal to the Supreme Court. And the Supreme Court, they say this, I mean, they'll come around and say it. Appeals on M cases are different. They look at them closer, and they look at the lawyer's conduct during that to see whether they got a fair trial or not. So I really believe that these defense lawyers are really not doing a job that they should be doing for their client. I know.
Yeah,
That's my opinion.
I think that the defense is waiving a lot of appeals. I think that Lacasse issue was one that they totally waived that issue for appeal. A lot of the leading questions, they're waiving that issue, and it's correct. It's the right thing to do as the appellate court to waive that, because if you make the objection timely, the state has the opportunity to change their question and fix the problem. If you don't object, you can't go back afterwards and say, oh, this totally ruined our case. Well, if it was ruining your case, you should have objected. And that's how it works. That's how it should work. Again, I think their strategy is on the better side of what you have to choose from in this case. You don't have a great strategy, but I think they chose one of the better strategies so far. I think some of the cross-examination has done well. I think pointing the finger and not being afraid to point the finger at Charlie and Wendy and Katie, I think that's appropriate. I think that's a good job. I think that's smart. So kudos to them for all of that. But I think as far as their objections, their evidentiary arguments, and really being on top of it, it has not gone as well for them. And they have to take a break almost every cross-examination. It's like they're not ready to get up and start crossing the witness. The prosecutors, on the other hand, I feel like have dominated the courtroom, dominated this trial. And part of it is because I think the defense is letting them. And that's part of the problem for this defense. But the prosecutors know this case like the back of their hand.
Well, it's important. And again, anybody who's seen a criminal trial, there is always going to be a side that's going to dominate the courtroom. Mm-hmm. And you want it to be your side. So, this fight, there should be conflict between the defense and professional conflict, nothing, you don't throw wads of paper at them, but professional conflict between the two in order to dominate a courtroom. There is no fight going on here to dominate that courtroom. These prosecutors are totally dominating the courtroom.
And just FYI, you can dominate the courtroom and still lose, because good lawyers have bad facts and bad cases sometimes, and you still lose, but you fight no matter what. Okay, Jeff Lacasse, what did you think about him?
I thought that Jeff was a good witness for the state. I really did. And at the very end of his, I'll jump to the end of his testimony, then I'll kind of go through. But at the very end of the testimony, I went, they were setting him up.
You think it was not so subtle by the end?
Well, for some reason, it didn't hit me till the end that they were setting this guy up as a suspect. They really were doing that. Thank God he was in Tennessee on the day
Thank God he got a flat tire, right? It's like,
I gotta say that was just shot. You know what? I think it hit him too. I think he got the message as well that they were trying to set him up.
It's funny because in some other trials, people have not liked him as a witness. I do think he did better this trial than in Charlie's trial. They think some people were like, it seems like he's just, butthurt or a scorned lover or whatever. And he kind of reached on some of the stuff he was trying to testify about. But I do think he came off better this trial than Charlie's.
Oh, yeah. And he gave some very key testimony, very important testimony. He gave some testimony about how Donna was, how she dominated the family and very involved in every aspect of Wendy's life.
I think the
Um,
defense did a good job of nitpicking that he didn't really know. He only met her like twice. I mean, again, I don't think anybody but really Rob is who I felt like was like, yeah, that shows me Donna's controlling. But
well, well, we haven't gotten to the text messages or
oh yeah,
the,
yeah,
the
yeah.
calls yet, but and then we've got he knew about Charlie's girlfriend and that her husband had a violent criminal record. I don't know how
Mhm.
that got in, but that got in.
He hung
Um,
out with them.
yeah, and then we talked about Wendy said her brother looked into hiring a hitman.
He
Uh,
made a joke, but she also
yeah,
said, I have to tell you something in confidence.
and it
Mhm.
almost made him throw up. I thought that testimony that was so that was good for him. And then, of course, we've got uh, the fact that she delays their breaking up by a week for some unknown reason, but it was the week right before the death, and that. Um, but luckily, he was in Tennessee. And then let's see, and that's I guess those are my highlights from him. But I thought
Yeah.
he came across real well, likable, and believable.
Okay, so we go from Wendy's ex to one of Charlie's exes, June. Not Katie Magbanua yet, but June. Anything to say about her?
No, not really.
I thought she was good for the defense. I thought she was a
Yeah,
good witness for the defense,
yeah. I
personally.
don't think she gave added anything really.
And then what about Charlie's ex friend Ryan? Who, this is a guy that everybody says really hates Charlie and he's like, Charlie was acting guilty. He goes overboard. He really hates Charlie, wants to do everything he can to help the state convict all the Adelsons.
Well, I mean, he basically, I think the only thing he really gave him is the way they wrapped cash. I guess.
Well,
I mean,
but he
that's
also said like he every time we talk about the crime, he would start acting, anxious and depressed um and acting guilty, basically.
and he also said that Charlie said you can get away with anything if you keep your mouth shut.
Yeah.
So I thought that was also an interesting statement. Uh,
All
but
right.
again, that was he was these witnesses were a lot shorter than I expected. Than this
They
trial
moved
went.
quick. The
Yeah, they
state
moved
moved
a lot
quick.
faster than I thought. Yeah, yes,
All right. The next witness was Investigator Hull.
right. Now I mean, she's technical for her. I mean, her significance is technical because she was able to go through all the financial records and show who got what, how they spent money, when they got paid money, how their bank accounts fluctuated, how they all of a sudden during this period of time they were flush with cash. During this period of time, they kept doing overdrafts. She let's see what else. Oh, the breast augmentation that came out of her testimony and paying for that,
Yeah.
and um, and how everything related to the bump as well. She had some testimony relating to when there were financial transactions that were relevant to the bump, and how things stopped as well relative to the bump.
So you don't know this, but because you didn't watch jury selection, I assume. But a lot of the jurors were saying they expect to prove a crime like this or conspiracy like this, that they would expect to see financial records and connections with money and things like that. And that's why I thought Investigator Hull was so important, because it was the prosecutor giving the jurors exactly what they told the prosecutor they would need to convict on a crime like this. So that's why I thought she was so important.
Okay, well, the next witness is Katie. Another, when they make this movie, Katie's going to have another actress that's going to play her part. Now, Katie, I mean, it's just so interesting to listen to this, so entertaining, at least for me as a lawyer, to listen to somebody who, number one, got offered immunity, turned down immunity. I mean, she was sentenced. She's in serving life right now.
Real immunity. She got real immunity.
Yeah, real immunity, and she turned it down. And she turned it down because her boyfriend was facing, I guess, the death penalty.
Mhm.
And so she turned it down. I mean, you talk about a loyal uh, partner in life. I mean, this person was incredible.
Or
Um,
I guess.
I don't know who her lawyer was, but I got to tell you, this is anyway. That was shocking to me. And then apparently she testified at her trial in her defense. Total fabrication, total story, total lie. And um, then she decides to cooperate. And she's received no promises or no guarantees or anything like that, but she hopes that it will help her. My guess, it will help her. I mean, anything's better than life, I guess. So it will help her. But so there she is. Yeah, she's another one to me, like, going back to Rivera. Independently, her alone, to me, no credibility. If they didn't back her up, if they didn't have things to cooperate, her testimony, I can't believe a jury would find somebody guilty based on a person who has this kind of history. She will lie in her own defense. She will lie when she testifies. She will refuse immunity to protect somebody. And then she'll come in here today and, hey, believe me, because I don't know, believe me, I'm telling the truth today. So obviously she filled in a lot of blanks for him of how things happened. She was again, this whole conspiracy is Donna to Charlie to Katie to the two hitmen. So they have now filled in the gap between Charlie and the hitmen. And so she was tremendously valuable. Yeah, she's going
I
to be
also
cooperated, so she's going to be valuable, but she was tremendously valuable.
I think that she is also so important because this was such a huge piece of the foundation before they hear the calls and the texts where they're talking about rental properties and they're talking about dollar amounts when it's really phone numbers, and when they're talking in all this code and saying all this stuff, she's in on these conversations. The Adelsons are trying to make it seem like, no, this is something totally separate, it has nothing to do with the crime. And now she has come and testified and said, yes, we were speaking in code. Yes, it was a hit that we were involved in hiring. Yes, all that stuff was bogus and a BS. So the jury's heard that before they hear the tapes. And I thought that was incredibly important foundation for the state to lay.
She also was incredibly important when they get to timing. When they talk about the money, and she comes to Charlie's house to get the money. And the money, right before that, we don't have actually Donna walking into Charlie's house giving him the money, but we have Donna there, and we have Donna saying, "I'm outside your house." We have those statements, and then right after that, again, the way the state's producing their case, Donna to Charlie to Katie. Right after that, Katie shows up. Charlie gives her the money, or actually doesn't give it to her. It's in the trunk of the car, and the money is wet. Why? Because Donna washed it. Because I guess that's what she thought was going to prevent evidence being used against her. So Donna washed it, and it was wet and could get moldy. So that timing, Katie's timing, the money, that's all going to be very important later on when we have all the technical information when they testify, that what Katie is saying is going to fall in line with all of that.
And that's the next witness as we start to get into the cell phone and the data and where they were and how you can prove where they were to line up and corroborate what in Sergeant Corbett, what uh, Katie said. Donna just left. They have a text message around the same time that says, I'm outside. Her cell phone data puts her near Charlie's house. So when we have a situation like that, that builds one after the next when you try to start putting the puzzle together as the state.
Yeah. One other thing, too, just going back for a second on Donna, I mean, not Donna, but on Katie, the cross-examination, never saw Donna, never met Donna, I mean, as far as this transaction goes. So she had no evidence, direct evidence of Donna's involvement.
Right. And I thought that was a good job by the defense. They've brought that out in a lot of witnesses, I think.
Right. All right. So Corbett, I mean, what can you say? Corbett's a technician. He is the guy from the Tallahassee Police Department. I believe he is the head of their technical department. And I think a couple of times he said, I've had over 1,000 hours of education and training to be able to do all this stuff. But his testimony is very important. He talked about tracing the rental cars, tracing the rental car travel, tracing the fact that on one of the rental cars, they got a ticket. So when he got a ticket, he went back and he changed rental cars. He also presented a summary of all the phone records, and and then he would juxtaposition them to the evidence in the case. And that was I thought, a great chart. So phone records, evidence. They said this, there's a call at this time from, this cell phone. They said this time, this cell phone. So that was a great bit of evidence. Problem is that stuff it's hard not to say that stuff doesn't lie. How can you say that stuff lies? So he also had I thought, a great PowerPoint. And there was one message where Donna says, erase this after you get it, after you read it. It was a text message. But we don't know. I thought this was interesting. And it might have been explained, but maybe I missed it. They never got Charlie's phone. So they don't know if Charlie ever erased the text message. But she said, erase it after you get this. And he goes on to the next day. If you want to move on, or.
Yeah, well, I think that his demonstrative aids were some of the best that I saw throughout the whole trial. But I also thought one of the missteps he made was after the depot, when the defense kind of baited him and were like, you never made that drive, did you? Then he goes and makes that drive, which is totally irrelevant to the drive from South Florida to Tallahassee 11 years ago. And then that gave them fodder for cross. That was one of the better parts of their cross, which he could have just avoided being like, I can MapQuest it and tell you the time it's supposed to take. And, but he fell into that. I thought that was kind of interesting lawyering done by the defense, and how sometimes the state might try to do too much, having him make that drive, 11 years later.
Yeah. And there was no reason. You're right. There was no reason to make the drive.
Right.
I mean, you think the same road 11 years? I mean, how many of us have driven to Tallahassee? You think it's the same road over 11 years?
Exactly. It's not the same road over 11 days, let alone 11 years. So what else did you want to say about his testimony, if anything?
I thought the testimony about using landlines versus using the cell phone, I thought that was good testimony. I think a jury is going to look at that and say, yeah, that's right. Why is he using a landline, instead of using his cell phone?
And then this was also, again, leading up to them hearing over and over, I'm going to call you from a landline, or let's meet in person, or they're using WhatsApp.
Yes. And then the Corbett also testified about the TV repair alibi. And that was really, again, we know it. We know the whole story now was Donna called and made the time for the repairman to come and repair Wendy's TV. It looks very obvious to me, and I think to the jury, that was setting her up for an alibi for the time of the death.
And if you remember, Lacasse said it looked like it was obviously not going to be repairable. It looked like somebody hit the TV and broke the screen, and then exactly the repairman comes over and he can't fix it. She's got to get a new TV.
Right. So, so that was brought up. Then we have Wendy and Dan's text messages. The fact that they're bickering. A lot of this stuff, I admit, the state is putting their own spin on a lot of evidence. But once it gets to be such a big mound, their spin really starts to make sense. I mean, if they just had Wendy and Dan's text messages and they said she was just giving herself the bickering to give herself an alibi, all right. But then when you start to put everything together, then it does start to make sense. And what the state is saying does make more sense. The next guy, and again, only because the made-for-TV part of this show, is the undercover FBI agent. His testimony was pretty short, but the jury loved him.
They were all laughing. Oh, yeah.
He was a great guy. He was strong. He testified clearly. I mean, his enunciation was perfect. And I expected not to hear that because in his undercover role, I'll bet he doesn't talk like that. But his enunciation was perfect. You and I had a trial, and I've had multiple trials where the identity of the witness is hidden. And so they did a great job, and that person instantly becomes credible with the jury. I mean, come on, we have to hide his identity because, of his super secretness. But he did a great job. I mean, it was short testimony. Didn't really have a lot to say other than I gave her the note. I called her a couple of times because we had to, again, in his words, tickle. And that's an important word. A lot of times I've been involved in wiretaps and nothing happens. And nothing was happening on this wiretap. It was ongoing when this bump happened, and it was dead airspace. So they had to try to do something to tickle it to get things moving. This bump was a tickle, and the tickle worked, and they got some tremendous stuff on a wiretap. But like I said, it doesn't always work that way, but in this case it did. That's really all I got to say about him, other than he did a good job.
I didn't think he did a great job necessarily in the
thought-
bumping, but his testimony was great.
Yeah.
All right.
Yeah.
Who do you want to talk about next?
We can jump to Stratford.
Okay. So yeah, he's been on the stand, or he was on the stand multiple days. He went through all the recordings, a lot of text messages, things like that. What did you think about his testimony? What was some of the more important recordings you think that stick out to you?
Well, even before the recordings, I think was important his testimony about Rivera, where apparently he did the debriefing of Rivera when he wanted to cooperate. And Rivera gave them 3 key facts that they didn't know. And again, Rivera on his own, I don't know if I'd believe him. But when you start corroborating a guy like Rivera, then he becomes believable. This was very important to Rivera's believability. First, that Garcia shot a hole in the rental car. They actually went out. The rental car was sold. It had been painted. They did a great job. They went out and they found the car, and sure enough, there was a bullet hole in the car. Then Dan traveling on the following day. They didn't know about something about Dan's traveling, so they checked that out, and sure enough, they found out Dan was traveling on the following day, following, I guess, when they were supposed to go up. And then lastly, the trip in June. They didn't know that they went up in June. But then when they went back and traced all the cell phones and all that stuff, they found out, sure enough, they went up in June. So Garcia told them 3 things they didn't know. Therefore, Garcia is telling them the truth, and he can be believable now. All right, so phone calls. I don't know, what you can limit as what's important, but we got the mention of blackmail. We have Donna saying that after the bump that the TV was about 5. Again, TV. You have to know about Wendy's broken TV to know that she's talking about stuff like that. And the $5,000 that was asked for during the bump. So that came out. That basically he went through days of, I mean, you can't go through it all, but Donna was at certain places, then Charlie, then Katie contacted Charlie, then Charlie contacted Donna. Then Donna contacted Charlie, and Charlie contacted Katie. Then Katie contacted Rivera. I mean, it went over and over again, the sequence of events. I mean, there were dozens and dozens of sequence of events just like that. So, I mean, again, there's no reason to go through all of them, but they made a very tight pattern of Donna to Charlie to Katie to the hitman and back and forth. So it's hard to ignore that.
And they did a good job of playing some so they could get to know Donna and Charlie, and who was calling the shots, and how Charlie thought he was a big shot, and how Donna would call him to take care of a problem for her, how they would meddle in Wendy's plans, make plans for Wendy, whether she liked them or not, with jobs and houses and boyfriends. So I do think they did a good job of picking those out. And the jury there's no need after these recordings to call Charlie Adelson, because I think the jury does not like Charlie after listening to all these recordings.
Especially I think the women probably hate him. Not just because he's a player.
Why would I want a 36-year-old Victoria's Secret model when I can get a 25-year-old? I don't want any kids farting in my face and stuff. I mean, it's crazy.
And then the stuff he said about Wendy on that one call, that was just awful, brutal. And then we've got, and again, they did a good job. We've got these videos of it at restaurants. We've got these.
And jurors think that's cool. It's like you have an undercover cop and they're filming them and recording them. And they only do that for bad guys. Another thing a juror said in jury selection was, I don't think we'd be here if they didn't have a lot of evidence against her all these years later. Oh. What do you think they think when they hear the FBI was involved with undercover tape recordings? Like, we've had cases with that too. And when they have the undercover tape for it, and by the way, everybody was making fun of Charlie saying stuff like, we shouldn't talk on the phone. And then he would talk on the phone for 30 minutes. We know they're wiretapping us. I told them about our case where our client would say that all the time. Like, there's people that are trying to record me. It's like on the FBI recording, he's saying that.
Did you ever, just a sideline now, Cheech and Chong. I don't know if you know who they are.
I know who they are. Yeah.
They're comedians, and they were great during the era of marijuana and getting high and stuff.
Yeah.
And they have a comedy bit where some guy's supposed to bring one of them's supposed to bring the dope over to the party, and he calls up and he says, "Hey man, I got the stuff," and he goes, "I told you not to call me on the phone." "Oh, okay, man." I mean, it's hilarious, and that's what these guys sound like.
Exactly. Exactly. All right. Anything else from the recordings?
No, I mean like I said, they fit perfectly into the state scenario of
The
how this.
story the state is telling. It's just too good of
Yes,
a story. That's what I said about this case. That's what I'm going to say when we get to the end of this and the final questions I have for you. But the story is just too good for the state when it comes to this, just fits together.
yeah, it
All
is.
right. The last couple witnesses we saw before starting this was the Miami-Dade cop who executed the search warrant with, a letter that, Wendy. So I do think we should talk about at the end of Sanford or whatever his name is, um, the extradition, the one-way ticket to Vietnam. How do you think the defense did dealing with that? Let's talk about that before we get to the jailhouse snitches.
Okay, I think. Well, I mean, they did as good as they could do. They talked
I
about.
agree. It was better than I thought.
Yeah, they did as good as they could do. They talked about the fact that they travel all the time and they always come back. And I found this really interesting. Apparently, they called the state attorney's office and said, "Is there any reason why we can't leave the country or why we
Well,
can't travel?"
we didn't get to dig into that because there was an objection and it was clearly sustained. So they started to get into it, but we didn't really get the full story there. But that's what it sounded like to me too, is that they cleared this with the state. They were going to surrender themselves if there was a warrant for their arrest. They
Right.
knew it was obviously a possibility after Charlie just got convicted. So
Yeah, so they did as
and
good
they
as they
say
could
a
do.
90-day tourist visa.
Yeah. And they also asked the question, again, I can't remember it, but they asked the question, is that extradition, is murder, I mean, is that included in the extradition? And I think nobody answered that, whether that's an exception to being
Oh, I
extradited
thought the
from
answer
Vietnam.
was yes, that is an exception
Yeah,
in Vietnam.
like I said, I don't remember, but the fact that that is an exception, that was also very key to their cross. So I think they did a decent job of crossing on that.
Um, All right, now we can get to the jailhouse snitches. The first one said that Donna told her she did do it, but she did it to protect her grandkids, and she wanted her to lie about what Katie told her in a prior jail stint.
There's an important, and I think you're going to hear this again in closing. What Donna said was, it wasn't supposed to go that far.
Oh, okay, yeah.
Yeah, that Donna said that, and I think you're going to hear that in closing, because that's a hook for the defense. Because the fact that what did she intend, and
Just to
that's
scare him or whatever.
right. So
Yeah,
maybe that's a hook. That may also be a hook.
you have to admit a lot of things, but
She also said again about the lying, and she was going to give them land, money, and a trailer
oh
as
yeah,
as
and to
her
fix her teeth,
right.
some veneers.
All right. So that was again. That's one of the people that again an opening statement we heard that she tried to bribe people to lie. So
Mhm.
obviously, um, Patricia Bird is one of them from the
Yeah,
jail. And then they had then you want to go to the second one?
I didn't watch the second one, so if you did, sure.
Now, the second one was interesting. The second one is she, they asked her, "Aren't you known as dishonest?" "Yes, I am."
How many witnesses are they going to call that admit to being dishonest? I mean, that's the problem. And that's the other thing is if this was not a good case, I think they'd get hammered for some of this. But
Yeah.
because it's such a strong case for them and this story makes sense and the general public believes they know what happened, they're able to get away with some witnesses that I think most trials we'd be like, you shouldn't have called them. Like somebody that's known for being dishonest, you should only put up their reputable, credible evidence. And that's an issue. That's an issue. This is different than Catherine Magbanua. Any prosecutor puts Katie Magbanua up there who said she didn't do it. Now she says she did it. This witness, I think, saying that is a little bit different. I haven't watched it yet, but that's a little different.
And then the other things she did try to bribe her to give false testimony against Katie. That's the second person. Then we had the interesting sidebar, I guess, became a
Oh
sidebar.
yeah. So let me
Yeah,
set that. Let me set
yeah.
that up, and then I'll get your take on it. So and I don't know if you know the backstory. So again, I haven't watched that Andrea witness yet, but it was specifically dealing with that Andrea witness, who's the second Jailhouse snitch. There was a motion in limine to strike her testimony. I don't even know what the judge's ruling was. I don't know if the defense waived it, but the judge ends up swearing Donna Adelson in and having a colloquy with her, which is a under oath question back and forth between the judge and the defendant, usually requested by defense counsel. That's usually when this happens. And he was basically like, are you cool with your lawyers crossing this witness this way? Are you good that it's, in your strat or in within the strategy? Do you agree with all of that? And tons of people were reaching out to me saying, I have never heard this before. I've never seen this before. This must be a Florida thing. Did it surprise you? Why do you think it happened? And is it just a Florida thing?
Well, first off, it's not just a Florida thing, and it does happen. And I don't
It's
know
happened
if
in federal court too.
what
It's
do
happened in
you
federal court.
do you remember we did it? Do you remember
Yeah,
that?
it has happened in multiple cases that I have seen or been a part of.
Okay, because we did it because our client, we wanted to put a witness on, and our client did not want to put the witness on. And so we told the judge that, Judge, our client is telling us not to, instructing us not to put a witness on. So we want to make sure that, it's freely and voluntarily, and that it doesn't come back to basically bite us that we didn't put this witness on. And there was a colloquy between the client and the judge that the client agreed that, yes, he did not want the witness to be put on. And so that ended the conversation. So you do that, lawyers do that to protect themselves. And this is what's happened here. I don't think we know the details of it, but this is protect you so that later on she doesn't complain that you did something and that you did it to her detriment. I can theorize, I can guess, but that's all I'd be doing.
It is a CYA that lawyers do when there's a disagreement. Either the lawyer wants to do something that the client doesn't, or the client wants to do something that the lawyer doesn't, or the client has seriously objected and told family members that, she objected to you doing something and then now she agrees to it. A lot of times you want to get that on the record. So a lot of people are saying like, oh, there's no way that this is going to protect you from ineffective assistance of counsel. This client, doesn't know what ineffective assistance of counsel is, or Donna Adelson's still going to sue them for ineffective assistance of counsel. Absolutely. She's trying to set it up. What are your thoughts there?
Well, first of all, it does protect you. If it's done right, it does
to a certain extent. Like it
Right.
absolutely is something that the other side will cite in your ineffective assistance of counsel appeal. It's like, the defendant was on the record and of sound mind and agreed and waived this, but there are lines, obviously, if you do something horribly unethical or that nobody would say is appropriate, you can still get there, but generally it is a pretty good protection.
Right. And in this case, it sounds like, again, I'm theorizing, it sounds like they may be going after an admission of her doing something wrong, and they want her to agree to the fact that they're going to admit that she did something wrong. Now, I don't know if that's it, but they talk about strategy, and that could be a strategy, is to go ahead and admit something in order to get a lesser charge or a lesser crime.
It's a bit of a hedge. It's like if the jury sees you being honest about something you did wrong and you admit it and you feel bad for it and you still maintain that you didn't do this other thing like the M, then maybe they'll say, oh, she would have admitted it if she did what was wrong, just like she did with the bribing. I don't know. It could be, but I don't know where it's going because they did a lot of this up at sidebar, but that's not that abnormal to me. I mean, it doesn't happen in most of our cases. It's only happened like I've probably seen it 2 or 3 times in cases, but and it's not just state cases, it's also federal cases. I think most judges around the country would do that if you asked them to do that as a criminal defense lawyer, right?
Right, because judges don't want to be reversed on appeal. So, they would
right there do it.
Right. So the judge protects himself too. It protects his record in the trial if he does it.
Yeah. No, I think that's true. Okay, final questions here before we close. The question everybody wants to know. So they've done one person at a time, basically. They did Katie and Sigfredo together, and it didn't go well. They convicted Sigfredo and were hung on Katie Magbanua, the first trial. They retry Katie, she's convicted. Then they indict Charlie. They try Charlie, he's convicted. Then they arrest Donna. They're trying Donna if she is convicted. Do you think they continue that trend and they file against Wendy or Harvey or both? What do you think after listening to this trial? Do you think they have enough evidence to go forward on those additional potential co-conspirators?
From what I've seen, I don't think they have it on Harvey. at all. Um, Wendy, unless somebody flips in the family, I don't think they have enough on Wendy. Now, I'm not saying it's not possible in this case. Let's face it, having somebody flip. That's but who knows? Charlie, frankly, Charlie could flip on Wendy. It wouldn't surprise me because apparently he has a real high opinion of her. So Charlie could flip on Wendy, and then they'd have a case. But unless somebody flips, I don't think they have a case on Wendy.
Yeah, I think potentially Charlie's the most dangerous of the Adelsons, so I don't know that the state would want to give him a good deal to flip on Wendy. There was rumors that they offered Donna uh, time served if she would flip on Wendy, and rumors are she said no. I don't know if that's true or not, but let me throw you my theory. If I was a prosecutor looking at this case, I think there's kind of two ways to look at it. Legally speaking, I don't think I would feel if what we're seeing is all the evidence. I think I'd probably feel like maybe she was in on this. Maybe she knew something at least after the fact. I don't know. Maybe she is guilty of something. I don't think I'd have enough to prove the case beyond a reasonable doubt. But if I was an unethical prosecutor, and I'm not calling anybody unethical if they do indict her, okay, so just save that. But if I just cared about winning and getting the big fish, I think it's a good enough story that they could present this same exact trial and say, Wendy obviously knew. She's the one that benefited. Look what she did before. Dan Markel's tag number is in Donna's planner. She's the only one that knew exactly where Dan Markel was going to be. Look at this voicemail. She drove her van right by the house to check to make sure the deed was done. She moved to South Florida. She changed the kids' names. Like, I think the story tells itself and is good enough to where if most jurors are willing to convict Donna and Charlie and maybe Harvey, I think they might be willing to convict Wendy as well because the story, the theory, and the motive connects.
Well, if you get to a jury, you always have a chance of winning. I mean,
Yeah.
there's no doubt. And plus, let's face it, people think prosecutors are doing the right thing, and that prosecutors don't prosecute innocent people. But I've got to tell you, the thing they've got in this case they don't have on Wendy is the trail. I mean, there's a constant trail of Donna, Charlie, Katie, hitmen, back and forth, back and forth, back and forth. There's
Train
none of that
cars.
for what?
There's the train cars, they call it.
Right. There's none of that with Wendy. So they would not have anywhere near as good a case with Wendy. They would charge it as a conspiracy so they could introduce all of this evidence into that case, which is, by the way, one of the things about a conspiracy that makes it nice is you can just put everything in by everybody.
And you get to say we've already convicted all of her co-conspirators.
Right. So, but I got to tell you that train that you refer to is just not there with Wendy. And that's the part that gives me a problem.
There are also so many text messages and recordings that if I'm Wendy Adelson's lawyer, that I could play where they say, Wendy doesn't know, don't tell her. She doesn't know anything anyways. We don't want to stress Wendy out. Hopefully he doesn't call Wendy. There's so many things like that where they're isolating Wendy. She doesn't know that she's not in on any of these text messages. She doesn't know who Charlie's paying and hiring at the Adelson Institute, unlike Donna and Harvey. So I actually think Harvey might be easier to convict than Donna because if they can prove Harvey than Wendy, not Donna. Because if Harvey was with Donna when they dropped off the money, Harvey owns the Adelson Institute too. So if they're paying Katie Magbanua, maybe, he said they could do that, just connecting certain things like that, not as culpable. Everybody knew Donna was next when Charlie was on trial because there was so much about Donna during Charlie's trial. Now it seems like there's a lot about Wendy during this trial. So if they're following their MO, it sounds like Wendy might be next. But again, I think that's a much tougher case if she gets a good defense team.
Well, and I remember, you can remember some of these calls. There's so many of them. But I remember one specific one right after the bump where Donna calls Charlie and says, it's the two of us. She specifically said, it's the two of us. To me, that was a really key call. If you're Wendy's defense team, that's a key call.
Yeah, I think so too. So overall, do you think they're going to be next or no? You think they're done?
I think they're done. I mean, I do. I don't think that, I don't know. Donna was a key target because I think, again, they view her as the boss. And they view her as orchestrating the whole thing. I mean, I could be wrong, but boy, if I wouldn't want to try as a prosecutor, I don't think the Wendy and Harvey cases are good cases.
Yeah, I don't think Harvey's worth trying it against. If they think they have enough against Wendy, then I could understand why they would do that, especially for justice for the Markell family, who probably, I would say, thinks that she was involved. But we'll see, because you never know with this case, and they're doing it kind of in unconventional ways. But we're done with the state's case, basically, I think, either at the end of the day today or very early on Tuesday. Defense's cases are not usually as long as state cases. So you think the chances we're done with this case next week?
Oh, absolutely. I can't imagine it going, and especially the way these guys have crossed. I think that's an indication that, they're not going to drag this case on.
Do you think Donna takes the stand? Charlie did. I think she's gonna.
I think she has to.
I agree.
I think she's got to. I think if she doesn't get on the stand to explain all this stuff, I think she's dead meat anyway.
And I think she could really misstep trying to explain this stuff. I mean, I think it could be atrocious for her.
Can you imagine if again, the prosecutors may or may not do this, but if I was the prosecutor, I would do this. If they sat there in their cross and they went through each call, each text message, whatever they got. Okay, explain on why on 7/20 or blah, 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 you called Charlie right after the bump. What did you say? Explain that. So I just, it's going to be a brutal cross-examination. But what else do they have? If she can't explain this stuff, again, I would have said that they had a good chance of getting her off up until was it Stratford, that guy with all the calls and all the timings. I would say that they had a chance. I think that killed any chance with all those calls and all. It's just almost impossible to explain that.
Yeah, I don't. Charlie had an answer for everything. Some people said it was a little too smooth, but he was like sharp and studied everything. I don't think she's going to be able to do it the same way, but it didn't work for him either. So if it didn't work for him, I think it's even less of a chance it works for her. Yeah, I think we have a verdict by the end of next week. I really do. And I was planning to go to the trial potentially near the end of next week and go sit in the courtroom, but maybe it'll be over before I even get there. So we'll have to wait and see exactly what happens. But thanks for watching it. You're going to watch it again next week, at least. If it's over next week, we'll do one more recap the following week as the podcast. And maybe we'll be recapping to the verdict. We'll see what happens. But thanks for joining me as always. And until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.